Yes, Janelle Renee Manigault.
Thank you. Your Honor, I believe Ms. Manigault the test was overbooked and she was told that she has to reschedule.
This is never gonna end. So when do you have it scheduled now, Ms. Manigault?
I have to call again, sir. I have a toothache. I'm sorry.
What's my date in July? Get it set, please.
Yes, sir.
I'll just adjourn this out to July 19th,
Thank you so much, Your Honor.
2023, 9 a.m.
Court, for the record, I'm attorney James L. Galen Jr., P43406. Your Honor, I do not believe my client is on Zoom. I did reach out to her by texting her as well as calling her phone this morning. I did talk to her 2 days ago. I did call her mother this morning. Her mother said she's at work and she's trying to contact her. Can we pass on this matter?
Not really. Is she coming into the Zoom here?
I expect she will, Your Honor. She's never missed. I did talk to her 2 days ago. I've got no explanation as to why she's not already here.
She's got till the end of the block to show up. Otherwise, I'm issuing a bench warrant.
Yes, Your Honor.
Not here. Is the defendant here?
Yeah.
Neither the attorney or defendant are here. Not clear why. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That warrant will issue on the 9th, June 9th, 2023.
Your Honor, I'm sorry. That actually, please do not issue the bench warrant. I hope you didn't put the sticker on it. Mr. Noxie did contact me, and we did work out a resolution. He provided me with the proof, and the people would be moving to dismiss this case.
Case is dismissed.
Address one issue of bond once we address the adjournment.
We'll adjourn this matter July 7th or July 5th, 2023, 9 a.m. Esteban.
Yes, Your Honor, I have prepared an order to modify his bond, and the request to modify is to, I believe it's paragraph paragraph 5U, entitled Other, where there's a no weapons instruction that's been checked. Mr. Martin is a gun collector and has a large collection of guns, and he holds a valid concealed pistols license. He was requesting that the court modify his pretrial release order to remove that provision, given the fact that this is a failure to secure a load. He has no prior criminal history. It's not a violent offense. He's been compliant with everything else that the court has ordered. He just does not want to have to, if the court is willing to agree, remove all of his gun collection from his home.
Response from the people.
Your Honor, I would just leave that in discretion of the court. This has to do with an unsecured load, and so it doesn't really have to do with anything as weapons. But I told Ms. Hamoud that I would not be stipulating to it, and she would have to ask the court.
What I will do is I will delete the provision regarding the possession of weapons. There still be no, as a condition of his bond, he's not to use a weapon.
Thank you, Your Honor.
The people versus Nakidri Franklin.
Judge?
Who are you?
Joyce Christmas. I've been on the phone for the longest, and my phone is not working.
I know, it's a recall.
That's my client, Your Honor.
Yeah, I know.
I've been on the phone, and I'm on another phone trying to talk to you. I've been on the phone the whole time. I heard everything you said. but
Okay.
my phone is not working to unmute myself.
All right, Miss Christmas, it's okay, settle down.
Are we done?
Yes, Your Honor.
Yes.
Yes.
You need to go over to the Ypsilanti Court 14-2. You have a warrant outstanding.
Is
But
it
you
for a
gotta clear-
ticket?
Pardon?
Is it the one for the ticket?
Well, it's a driving while license suspended.
Oh, okay, and that is on Michigan Ave, correct?
Yes, ma'am.
Okay, thank you.
Thank you.
Is there a way
Exactly.
that you can, is there a way that you can clear that?
Pardon?
Is there a way that you can clear it?
I could, but I'm not going to. You need to go over there or to use the warrant process to do it.
Say that again?
You need to either use the warrant recall process or you need to go to the court to do that. You can talk to your attorney about that.
Okay, thank you.
Thank you.
And on behalf of Mr. Lambert, who appears via the Zoom app without objection to appearing in that manner.
Mr. Lambert, can you say your name, please?
William Joseph Lambert, Your Honor.
All right, thank you. All right, what are we doing on these cases?
So, Judge, there's been the family has done a lot of orientation with the Veterans Home in Arizona. There is a bed available for Mr. Lambert. The last thing they are waiting on, and I've already been in communication with the jail medical staff, is a TB test from Mr. Lambert that they need prior to his admission. So they conducted one, I believe it was in late March, and we're working on getting those results sent to me, where I can forward those to this Arizona men's facility, at which point we believe he will be immediately admissible, as all the documentation other than the TB test has gone back and forth by now. So, Judge, the only thing that I would ask, and we do have his bond set up in Judge Valvo's court to allow him immediate release once a bed becomes available, is to make sure that's part and parcel of these matters, so that Mr. Lambert could go to a place with proper memory care, supervision, and the like in Arizona.
All right. So you want me to adjourn this out and adjust his bond to reflect that? Is that?
Yes, please, Your Honor.
All right. Any objection from the people?
None
So
from the township.
My concern, and I did speak to Mr. Siller about this as well, is that last time Mr. Siller and I approved for Mr. Lambert to be released to go to this Arizona facility, he returned to the jail with a PBT result of 0.169, and he returned to the jail at 1:28 a.m. And we were told in a bench conference with the court that he was going to be monitored at all times during this trip. And then he came back with a quite high BAC. So my concern is that if he is to be released, that he would just go straight to this treatment. We would get the proof of that, of him being at the treatment center from someone at the treatment center, and that we would get an update, because I have concerns about the court allowing his release to this treatment, when the last time we did, then he came back and he was intoxicated. So that's my main concern.
And
As
Your
is
Honor,
mine.
And Your Honor, I think we've buttoned up the cracks that allowed for that to happen. There was some brief separation on the flight based on seating issues that separated Guardian from Mr. Lambert. I've instructed the family, both guardians, one, that we would be looking at a very narrow window, and that we would propose nothing less, and I'm sure the court would demand nothing less, between the time that Mr. Lambert is released, get on the plane, show up in Arizona. Also, I have the declaration from his guardians that they are not going to allow any sort of separate seating scenario It was how these tickets were purchased, where the seat was not determined. But this time they understand they're going to be seated immediately next to Mr. Lambert, and to not allow, obviously, neither of them is on board with any violations of bond or alcohol consuming activity. So I think we can button that up sufficiently with orders that would attend to his release. But we have no objection to release with those safeguards in place to ensure that Mr. Lambert isn't drinking during any pendency or any point in time between his release and admission into the Arizona facility.
Okay, well, it seems to me it's one of proximity to his guardians as well as the time frame from release to admission.
Both,
So
Judge.
what I will do is I will adjourn all of these matters out to July 5th, 2023 at 9 a.m. What I will indicate is that Mr. Hall, you can prepare an order and get the signature of both the township prosecutor as well as the state prosecutor with the provisions that would ensure that immediate transfer over, as well as making sure, as you're indicating, that if the basis for it is, basically he has to be within sight accompaniment of any guardian until such time as he's admitted. Once I get that order, I will sign off on that for his admission. I mean, obviously that's the best thing, but I think Ms. Kirby's point is a good point, that we have to make sure that he's not drinking.
Absolutely.
Okay.
Thank you very much, Your Honor.
Hopefully we can have some further information. There's quite a few cases across the courts.
Well, are you gonna put the other case in there too? The one that I have for the 20th? I think it's at this court also. The one that was dealing with that DUI?
We're going to try to get all of them handled together.
Well, that sounds good. What kind of resolution do you think I might have at that time?
Well, why don't you talk with your attorney when everybody's not listening?
Yes, sir. I didn't know, sir.
Okay, that's fine. I'll adjourn these matters to July 5th, 2023, 9 a.m.
On his community corrections violations report, there is almost 2 pages of missed tests or rescheduled tests that were missed. On 5/19, which is the latest notification of the drug testing at 4:10 p.m., the defendant blew a .03, and he was required to retest every 15 minutes until he completed a compliant test, and he failed to do so. Yeah.
My main concern, Your Honor, is not the 5/19. I mean, that is concerning, but on 4/15, the .332 is my main concern. I mean, that's extremely intoxicated. And I did have a long conversation with Mr. Shand about this before I agreed to that 90-day adjournment on the record, if you recall, that I was in favor of it so that he could get some time in. I fully trust Mr. Shand, and I'm sure his client probably told him that he could do it. And while he did do the 90 meetings, to my understanding, this is not acceptable behavior. And regardless if he's doing the meetings and or getting treatment, this kind of violation report, I would be asking for a remand.
Mr. Shand.
Well, Your Honor, on the date in question of 4/15, where there was a 332, he did not retest, and they missed 5 or 6 times to retest. However, he tested between 9 and 12 that same day, and there was not a violation. I don't know what happened that day. I've asked my client. He said he did not drink, though that was one of the only 2 times in the 90 days that he actually had any type of alcohol in his breath.
On the 15th, he's saying he did not drink?
He did not. And at the test that he took between 9 and 12 that day, he ended up passing that test because it's not a violation. And I don't know why there would be such an aberration, 0.332. Obviously I've known Frank for a long time, and I know the way he drinks. He's a 1/5 to a 1/2 gallon a day of vodka drinker. So if he was at 0.332, I don't think I would have ever seen him again. But obviously that night he passed between 9 and 12 because there's not a violation. And on the 19th of May, when he did blow, he had very low numbers, 0.03. He had an ETG done the very next morning, and he passed. It was negative. So we have an ETG report from 5/20 at 11 o'clock in the morning, and he was negative.
I don't see, okay, and maybe you're referring to the absence of a test or an absence of a report.
Correct. There was not, if he was testing 3 times a day, if he had missed the 9 to 12 that day, it would have been a violation. He didn't miss, and it's not a violation, which means that he did not blow any numbers. If he blew 0.332 at 2:50 in the afternoon, the 9 to midnight blow, he would have blown some numbers, because there's no way that much alcohol can be out of your system by the 9 o'clock test. It's not a violation. It was not a violation at 9 to 12. The fact that he missed all those retests is concerning, because he should have been testing. And I don't have any excuse for that. However, the fact that he passed the test at 9 to midnight on the same day that he blew 3s in the afternoon doesn't make any sense to me. And as your honor very well know, I was a guy that blew 3s on a regular basis because you put me in jail because of that a couple of times. So I don't understand why there was such an aberration in the testing, because he should not have been able to pass that evening, and he should have it should be a violation for either not testing or failing between 9 and midnight.
I would tend to agree with Mr. Shand on that, because I mean, I'm concerned on the 19th, is he saying that was also some aberration?
Well, he said he brushed his teeth and used mouthwash. I know. I said that's been heard by Judge Simpson about 73,000 times over the last 25 years. So, however, he did call me about that, and I said, you need to get an ETG done, and he did go the very next morning, an ETG done on the 20th of May, and that was negative.
Okay. So I'm a little bit worried about this report also, because I'm looking at this, and I think Mr. Shand's right. I mean, if you look at just unless he has some extraordinary elimination rate, that 415 test, I'm assuming he took a test later, but I don't see that.
But they're only listing the violations. Therefore, if he took the test later and he violated, it would be a violation. He took the test later and passed.
I've seen it laid out both ways. So, but I get your point. I mean, I've seen it where they then tell me when the next good test is. So at least we have a framework. Here, I'd be making an assumption, but he would have had to test on the 16th, 17th. And I don't see that. Well, what I would do is I would set this for a hearing, because I got to have some understanding of why it's a 3-3. I would agree with you that if there is a past test, that's not going to make sense in terms of just how a human eliminates alcohol. So I will set it for a hearing on the bond violations. When can I do this? 21st. Yeah, but I'm gonna need a special time. I'll set the bond violation hearing for June 21st, 2023 at 3:30. Interim, however, Mr. Mahoney, this is, and it's not, I'm not doing this to punish you for bond violations I haven't found. My problem that I'm having here is you're not testing timely.
Yes, sir.
So, or regularly. Okay, so I'm gonna order in the interim between now and then that the defendant is to report to community corrections for placement on a scram tether.
That would be fine, Your Honor. I think that would be really helpful too, because I sent a long email to Caitlin explaining Frank's retired and his schedule is not a set schedule, and he seems to have problems testing at the right time. And I think a scram tether will be able to give everybody a clear picture of exactly what's going on. And I have no objection to him continuing on tether either, even after we have this case resolved, because I want him to be comfortable. I'm not just his lawyer. I'm his grand sponsor too. His sponsor is a guy that I sponsor. So we talk a lot, and I'm really interested in his continued recovery. He has been doing really well so far.
So what I'm gonna do, you understand that, sir?
Yes, sir.
All right, you need to get yourself over to community corrections today. Get that switched, and then we'll see you on the 21st at 3:30 for the bond violation here.
Yes, sir.
Is that via Zoom, Your Honor, or in person?
That's gonna be in person.
I get to see Miss Kirby.
Yes.
That's everyone's favorite thing to do.
Well, actually, I get to see Judge Simpson. That's the highlight.
No, I'm not gonna talk to any of you. All right, anyway. All right. Take care. Thank you.
Thank you, Your Honor. Thanks, Caleb.
Bond will continue in all other aspects.
Mr. Malone also has a felony case for which there's an offer to reduce it to a misdemeanor if he completes treatment. He's completed treatment. He is now literally just yesterday moved into transitional housing. So he is doing very well. And that case would be handed down to this misdemeanor docket. And so I was hoping to adjourn it so that we can try to get both of these cases coinciding on the same.
How far out? He just started transitional?
Yes, but he has completed the treatment. His next PCC date, I believe, is the 22nd. And I have forwarded his certificate of completion both to Ms. Kirby as well as my coworker who's handling his felony case, so that can be provided.
June 5th or July 5th, 2023, 9 a.m.
Thank you.
Hey, Judge Simpson. Judge
Yes,
Simpson.
sir.
Hey, I heard you called me, huh?
I called you.
Something from my office to Judge Simpson or something like that. That's how I was doing. Somebody did from your office.
Nobody. I'm sorry. I don't know what you're talking about.
Somebody said somebody had got a call from Judge Simpson's office. I don't know. But I'm doing good. And the 90 days really did a good thing for me. I'm going to thank the court and everybody that helped me out. We got to find a new foundation, get a new lifestyle. I've been clean since December 5th, 2020. So I'm doing good, man. I don't think I'm going to go back out there. And, to help everybody else, I got to give back into this program. It's a simple program. As long as I keep it, don't pick up. Because life is short for a lot of people. And I've been doing this stuff 36 years. And I'm tired, man, And I'm thankful for the help. I'm thankful for Dow's Farm. I got to do what I got to do. It's up to me to do it. Nobody else can change you. Change yourself but yourself. So thank you, sir.
All right. You just keep it up. Because you know how I am. So if you go back to that other way, I'll be out there in the street somewhere. I'll roll up on you. Then I'm just going to grab you. You know that, right?
Yes, sir.
All right. Yeah, all right, Mr. Malone. You take care of yourself, fella.
Yeah, thank you.
Location 2401 Glencoe Hills Drive, Pittsfield Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Disturb the peace.
Okay, that's a conclusion. But what happened on that date? Were you at a healthcare facility?
Was I at a healthcare facility? No, I was walking, and the police, they pulled up on me, and they said that I had blood on me, my feet and my hands was cut up, and they took me to the hospital. They said I was intoxicated, but I was
Okay.
lost. But it's a long
right.
story.
So, but you were walking up the street you were in the area of Trinity House. I guess it just says
I
this.
believe they took
When you
her there.
when
Yes,
you
I was
got to the hospital.
basically lost. Yes, I was basically lost.
Okay, but when you got to the hospital, what happened there?
What happened there? I really don't remember that much, but I know that I was lost and they took me to the hospital, and I know they tried to basically sedate me because a man said something probably
You were
rude to me,
kind
and I said something. Huh?
Okay, but you were out of control. Would that be fair to say?
I was under the influence.
Okay. And you being under the influence kind of made you out of control and you started yelling, right?
That's fine.
That's
Yes.
why that's where they were going to try to sedate you?
Yes.
Okay. And you would agree that your behavior what disturbed the peace and repose of the area surrounding you. Would you not? Would you agree to that?
Yes. Yes, I would agree.
Okay. All right, very good. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is also satisfied.
All right, court will accept the defendant's plea of guilty to this charge. Defendant referred to probation for a pre-sentence investigation and report and consideration of the prosecutor's deferred. Young lady, let me ask you a question. Do you drink much?
No, I don't.
Okay.
You can look at my record. My record is clean. This is my first offense ever, as far as going to court for it. I don't get in no trouble.
I wasn't asking about that. I just asked if you did.
No, I don't.
I worry when somebody's answering more questions than I asked. I'm going to leave it to probation as to whether or not, but you have the court's authority, if necessary, to send her for a screening and assessment. At this point, though, I will just refer for a pre-sentence investigation and report. Sentencing in this matter will be July 12th, 2023, 9 a.m. Ma'am,
Quick.
if you must.
So all of these notices that I received in the mail from the court, I'm not sure what part from the court to the post office from when the mail gets sent out, but my mail has been coming to my house open. It's been coming to my house open, and I don't even feel safe and secure to even open my own mail. So I just wanted to throw that out there.
Thank you. Court call.
I have a problem with that date. I have cancer and I have an
Okay.
MRI scheduled on June 21st.
Okay, that's then, all right, that's right. Will July 5th work better for you, ma'am?
That's perfect.
All right. Thank you for saying something. So we'll, July 5th, 2023, 9 a.m. And know that you'll be in our prayers, okay?
Thank you.
We'll explore that with them if the court be gracious enough to grant an adjournment, and I can
Yes.
contact Ms. Hightower Brown if possible.
Well, yeah, okay. And I don't, see, I'd grant it for Miss Pearson. I don't know about Mr. Pearson. He No, I'm kidding. I'll give him the adjournment too. How are you, Mr. Pearson?
Better that you're smiling, sir.
All right. No, I have to say this, Mr. Brown, they always appear there. And I think it's been 2 or 3 times they appear. And I have to say my staff was now, I don't say upset, were we? We were not upset. But the other times that they've appeared, they've actually been dressed alike. They look so cute together. And this time they showed up and they weren't, and we're like, okay, what's going on? And so I figured that the reason that they weren't that way, he did something he shouldn't have done. So I was blaming him for the whole thing, but I was just guessing. So I didn't know. Anyway.
On advice of counsel, happy wife, happy life.
He's not going to say anything. I know. Okay. Let's adjourn this out then to July 5th, 2023 at 9 a.m. Defendant's bond will continue. Okay, Mr. Pearson, you guys take care of each other, please.
Thank you, sir.
Thank you.
Irma Dadish on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Miss Sharon Reed. Could you please unmute and state your name for the record, ma'am?
Sharon Reed.
Thank you.
You're welcome.
Your Honor, this is a case where we are requesting a supplemental report from the police department. I know that Ms. Kirby has requested it, and we were told it was going to be provided in hopes that we can get this case dismissed. That report still has not been provided, so we could get another adjournment.
Your Honor, I'm sorry, Ms. Reed. So I actually received an email during the docket from the officer. He is actually off on vacation, and he said he was going to send over the supplemental, but he did confirm the property was retrieved. So I am going to move to dismiss at this time.
We have no objection.
You all right with that, Miss Reed? Miss Sharon Reed?
Yes. Yes, I am.
Well, I'm just checking. You don't need to have it. You don't need to have a grin that big. Case dismissed. All right.
All right. Have a good day.
Take care.
Thank you. You too. Bye-bye.
Court calls again. Did you get yourself married?
Yes.
Okay, so it all happened.
Yeah.
Okay. Well, I worried about it a little bit. I said she's traveling to those disputed territories of Ohio. I didn't know what was going to happen down there, but okay. Well, congratulations, young lady.
Thank you.
All right. Okay, so what we're going to do, just hold on the line. We're going to put you into a breakout room with probation so you can get information and everything. All right?
Thank you.
Thank you.
Have a good day.
You do the same. She looks happy for being married. Anyway, well, I'm sorry. I just thought I'd throw it out there. I didn't know. Court calls again.
On behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Vermeulen. Could you please state your name for the record, sir?
Eric Vermeulen. Eric Vermeulen.
Got it. Okay, what are we doing?
Your Honor, the people move to dismiss this case.
And we have no objection.
I appreciate you. Thank you. Thank you very much. Thank you. I mean, it brings tears to my eyes. It really does. Thank you.
Eric?
Yes, sir. Yes, sir. I was going to plead guilty for you.
No, you don't need to do that.
Thank you.
Okay, hold on. Do you see your whole screen?
Yes, sir.
Do you see Mr. Brown there?
Yeah, I don't see Mr. Brown, but I heard his voice. Hello.
Hang on, he's got to unmute. He was just
Hey, Mr. Eric, how you doing?
Oh, okay. How about yourself, Mr. Brown?
Hanging in there.
Good, good.
Good to see you, buddy.
Glad to see you too.
This is like a reunion from so far back.
Oh no.
It was the what was that case? The case of the magic bullet.
Yeah.
that
Two deer,
he supposedly shot one bullet, killed 3 deer. Yeah, you remember that.
That's impossible.
Yeah, I know. We knew that. You didn't. But anyway, he's still doing good. Okay, Mr. B. You take care of yourself.
Thank you very much, everybody. Thank you very much. Thank you.
Thank you.
Bye-bye.
Bye-bye.
Take care, bro.
My understanding yesterday when I talked to him that I wasn't going to get no misdemeanor, it was going to be a fine.
Your Honor, may we have an adjournment? My colleague was the one that spoke on the phone, and I'm just going through the notes in the file, so I'm requesting an adjournment.
And he had an emergency today. All right. So here's what I'm going to do, Mr. Billups, so you guys can get that straightened out. I'm going to adjourn this out a couple of weeks so you and your attorney can talk, okay?
Sir, I don't have a couple weeks, to be honest with you. I work a lot. I'm at work right now. I just went on break. I had to punch out. But
I can't. Go ahead.
I was supposed to get something like just I wasn't supposed to get no misdemeanor for this.
Okay. Well,
not no misdemeanor, but a fine. I agreed to a fine. A $250 fine.
And that would be typically the fine that I would impose on this charge. But your understanding is you weren't going to plead to a misdemeanor, right?
Yeah, my understanding, it was just it was supposed to be something about driving, but I don't know nothing about no misdemeanor. I didn't.
Okay. All right. Then that's why I'm not. Okay, Mr. Billups, hold on. I don't want to know because you and your attorney have your own conversations. All I know right now and all I need to know is that you thought it was something different than what we're doing. And so therefore I'm not gonna take your plea, even if you wanted to give it to me now, because I need you to get that straight with him. So I would adjourn it out 2 weeks, but if you want me to put it out, this case isn't that old. If you want me to, I can put it out to July 5th. If that helps you out in terms of having to take a break and working and everything. I mean, but that's the best I can do for you. 2 weeks or 4?
4 weeks.
4 weeks would be better. Okay. Then I'll do that for you. July 5th, 2023, 9 a.m. And that way you can talk with your attorney and everything and get it all straight as to what's happening. Okay.
Okay.
She talks so soft. What did she say?
No.
She talks so soft. I didn't hear a word she said. She said, anyway, all right. Fines and costs of $250. I'll suspend 90 days in jail. When can you get that paid, Bam?
I would say, can we do like 2 months?
2 months.
Look,
Well, yeah, no, I heard the 2 months. She wasn't quiet about that. She said 2 months. Came out kind of loud. She like, you know what? She like Shaw. She like Clay up there. He said, everybody trying to give me a hard time today. You really need 2 months to pay this?
All right, you can do a month. I just moved into my place.
You know, did you see that?
You know,
See, you really need 2 months. Well, you can go a month. How about that?
A month, yes. That's fine. I'll have to
just listen. Just stop. Just stop. Here's what I'm gonna do. I'm gonna quit asking you. Just pay it July 31st. So it's a little under 2 months.
Yeah.
All right.
That works for me.
Yeah, all right. But if you don't get it paid, we won't come find you. All right.
I don't need that happening. Okay.
Okay. All right. Take care, man.
Bye.
Thank you, guys. Everybody
like
have a great evening.
There's a reunion here with Ron today. Reunion.
I know. This is like it's like going to the old folks home. I don't know what that's like.
Oh wow.
Anyway, no. Always a pleasure, Mr. Brown.
Always a pleasure. Good to see y'all.
Yep, good seeing you.
All right.
Take
Take
care.
care.
All right.
Bye-bye.
14A stands adjourned. Thank you, Ellen.
Hey, Elin.
Thanks a lot, Judge.
Did it?
You guys
All
have a
righty.
good one.
Bye.
Bye-bye.
You guys
Bye-bye.
take care.
You too.
In a long and emotionally charged docket spanning multiple defendants, Judge Simpson navigated a series of chaotic hearings that revealed everything from simple scheduling issues to deep personal crises. It began with Janelle Monago, who missed her test due to overbooking and was ordered to reschedule immediately while her attorney struggled to locate her. A bench warrant was nearly issued until the prosecution resolved the matter by dismissing her case. The courtroom then shifted to a bond modification request for a man whose only violation involved an unsecured load. Since it was not weapon-related, the judge allowed him to keep his gun collection but prohibited any firearm use while on bond. Moments later, chaos erupted when Miss Christmas, confused and stuck on mute, appeared frantic about an outstanding warrant. The judge firmly instructed her to clear it through the proper process. The tone shifted again with Mr. Lambert, an elderly veteran with memory issues whose family requested permission for him to transfer to a supervised facility in Arizona. The judge agreed, but only with strict safeguards after learning that Lambert previously returned intoxicated with a 0.169 back despite being under guardian supervision. This theme of addiction resurfaced in the case of Mr. Malone, whose violation report showed alarming alcohol levels, including an unexplained 0.332, prompting the judge to order ASC-RAM alcohol monitor and schedule a full violation hearing. Yet, in a rare moment of hope, Malone later expressed gratitude for treatment, sobriety, and support from the court, moving the judge to stern encouragement but also genuine praise. The docket continued with a disturbing case involving a lost and intoxicated woman taken to the hospital after allegedly disturbing the peace. She pled guilty, expressing fear over mail tampering and revealing she was battling cancer, prompting the judge to adjust her sentencing date compassionately. Additional cases resolved quickly. One defendant's property dispute was dismissed after a supplemental report confirmed items were returned. While another celebrated her recent marriage, the judge joking warmly about her trip to the disputed territories of Ohio. In the final stretch, misunderstandings surfaced again when Mr. Billups, joining court on his work break, insisted he never agreed to a misdemeanor plea, leading the judge to adjourn his case so he could consult his attorney properly. The session closed with several fines imposed, leniency granted, and the judge balancing firmness with human understanding. Throughout, the courtroom showcased the full spectrum of real-life struggles, missed tests, addiction, failing health, relationship breakdowns, financial hardship, and small victories, all unfolding under the steady, occasionally humorous but always resolute guidance of Judge Simpson. For more information, like and subscribe my channel.